Good afternoon, everyone. I hope you can hear me. My name is Amina Merritt, and I'm a staff attorney with Housing and Economic Rights Advocates. And today we're here at the Sacramento County Public Law Library to present a webinar entitled What Tenants Should Look For in a Lease. This presentation is actually part of our Ask a Lawyer series, which will be happening for the next 6 months here at the Sacramento County Public Law Library. It's a partnership or a collaboration between Sacramento County Public Law Library and Housing and Economic Rights Advocates. We're asking that if you have any questions, you type those questions in the Q&A box as you listen to this presentation, and we will be answering questions at the end of the presentation. Please note that this presentation is for informational purposes only. It does not create an attorney-client relationship between anyone who's watching on Zoom and the Sacramento County Public Law Library or Housing and Economic Rights Advocates. We will provide additional information for resources at the end of this presentation. And if you want to have a consultation with HERA, we will give you the information to do that. So what we're going to try to cover today is here on this agenda. We've already done the introductions. I'm Amina Merritt, staff attorney, and Housing and Economic Rights Advocates is a nonprofit law firm based in Oakland, but we have attorneys all over the state who provide information on housing, economic issues, debt and credit, and you can look on our website, which will be provided at the end, for information on how to access some of our other webinars. So let's jump into this topic of what tenants should look for in a lease. This webinar is designed for tenants to educate California tenants, and we will be talking a bit about California law today, a little bit about some federal law, but mostly this is designed solely for California tenants. And we're going to cover some general considerations, the laws related to tenancy in California, and we're going to talk about some actual lease terms. So what are the general considerations? I want to talk about where we would be in the process when the new tenant is presented with a lease or a rental agreement. And I want to make sure you understand that, because the rental process has several steps in it. And as a tenant, you need to be sure of where you are in the process. So you've already completed the hunt for the apartment, the renter sees an ad or a sign for a rental unit, and they have gone in person or online to make an appointment to inspect or view the unit, and they've already applied, paid a fee or a deposit. And I wanted to note that HERA does debt and credit team trainings because some tenants need to repair their credit or have a better credit picture in order to be an acceptable tenant. And on those issues, our debt and credit team can help you. But the point at which we're going to be talking today is that the renter has already been accepted as a tenant and is sent an agreement to sign. And we're going to talk about the things you need to consider before you sign this legal document. The lease or rental agreement, what it is not an email to you saying you've been accepted as a tenant. It's not a letter saying, welcome to Sleeping Arms Apartments, we're going to accept you as a tenant. And it's also not a text telling you to come in and put down a deposit or to identify or pay a holding fee. And it may not even be the payment of the holding fee, although there may be a contract argument that causes promissory estoppel. But what the lease or rental agreement is a binding legal document. It's a written agreement between a tenant and a landlord. It is a written contract. And I'm emphasizing these points because you would be surprised how many tenants do not have a copy of their lease. They do not feel that they're legally bound to the terms and conditions of that lease agreement. And it is, once you put your signature on there, you have signed a legal document. It's important to understand that. And there isn't much difference between leases and rental agreements. Rental agreements are usually for a shorter period of time than 1 year, and a lease tends to be for a year or longer. Rental agreements can sometimes be shorter and have fewer duties and responsibilities listed in it, but otherwise the rental agreement and lease are the same thing. They're legal documents that bind the tenant to certain responsibilities and also bind the landlord to certain responsibilities. So as I said, a lease is usually for a particular term. And in this new rental market that we're living in, it's important to understand that many of the lease formats being used by landlords are very detailed, and they need to be because of the requirements of the law for landlords to give specific notices to tenants. And so if you, I'm saying caution, if you see a 1 or 3 page rental agreement, you might want to wonder if that is timely and complies with the law. And also if you see some old typed document printed up with a typewriter, or it's so old that you wonder if it is currently legally applicable, it probably is not. And you are able to look at the bottom of most leases and see where it came from. When I do this presentation live and in person, I tend to pass out some form leases so that people can see the actual lease. But you should look at any lease that you have and see where it came from. It'll be identified on the bottom on a footer of where that document came from, and whether it's a new format or not. So now we're going to jump into the laws that are related to tenancy, because there are such a variety of housing laws. It's important to know what law is applicable to the unit you live in if you have questions about your tenancy. And so some of the basic laws we're going to go over. There are, most of these laws related to landlord tenancy are found in the California Civil Code. And in addition to the California Civil Code, we have federal law in California. We have some county ordinances. Most of our California cities have local ordinances. There are public housing regulations under state and federal law. There are rules governing those regulations. In the state of California and nationwide, we've had emergency orders during COVID, and there are sometimes fire and flood orders, earthquake orders that affect tenancy. And then there are also administrative procedures in many housing programs, and also some leases and rental agreements provide for non-court remedies if tenants have issues with their landlord. And so you really need to know what law applies to your housing issue and what law applies to the type of housing that you live in. But in general, Civil Code Section 1962 governs signing a lease. And that statute says that a lease can even be oral, but there may be some contract law that applies. That's why I note the UCC statute, Uniform Commercial Code. The statute of frauds may require certain length of leases to be in writing. And also Civil Code Section 789 through 93 governs the signing of leases and oral contracts. And so those provisions specify the most important point in general for tenants is that you are entitled as a tenant to a copy of the signed lease within 15 days after you sign it. And I can't tell you how many tenants I have consulted with who never have received a copy of their lease or have never even asked for it, or realize that they have a right to have a copy of the signed lease with the landlord's signature on it, both your signature and the landlord's signature. That is a legal requirement. Also, I wanted to highlight the California Fair Housing Law that protects against discrimination, harassment, or retaliation in renting a unit. And the reason I focus on this is because I've seen tenants be discriminated against simply for asking for the copy of the lease. But the California Fair Housing Act specifies that you cannot be discriminated against in renting a unit on the basis of race, national origin, language, immigrant status, familial status, source of income, sexual orientation, veteran status, disability, or even the perception that you have those characteristics. And in California, our Fair Housing Act, with those characteristics and those categories of protections, is one of the most protective fair housing laws that exist in the country. There is the federal fair housing law that protects against discrimination, but it has fewer protective categories than we do here in California under the Fair Housing Act. So that's the law about the lease signing and your entitlement to a copy of the lease. The next general provision I'd like to highlight are: when can the landlord increase the rent, and is there rent control that prevents increasing the rent? This is a very important topic since COVID and since we had a moratorium during COVID. But in general, Civil Code Section 827 governs when and by how much rent can be increased. The landlord must give prior notice of the increase, and some of the rent provisions that have been enacted around the state prevent landlords from raising the rent more than 10%. Some cities and towns have limited it to 5%. And so wherever you live, whatever county, whatever city or town, there may be a local ordinance, there may be a statewide ordinance that applies to your rental unit. And so you need to know which Protection Act applies to you and how much it limits the increase of the rent. But it will be specified by code or ordinance, and that is the limit. And this is a big topic right now because landlords are attempting to raise rents to market rate rents that are not necessarily legal under the civil code, that may exceed the amount that Civil Code Section 1946 says that the landlord can raise it. And some landlords don't want to give the 30-day notice that is required. Some local ordinances may require 60 days notice of a rent increase. And we had the Tenant Protection Act of 2019 that is still in place. And there also are some CARES Act provisions that are still in place. Many of you will know that the emergency orders that existed under COVID expired around the state on February 28th. There are some counties, such as Alameda County, that extended the protections until July 25th of 2023. And there are also some local ordinances, some local towns and cities that have extended the COVID protections against eviction without cause, as well as limits on the amount that rents can be raised. And one of the other sources of laws related to tenancy are legal opinions by the court that further specify what landlords have a right to do and not do, and court orders that further limit that. This next page also talks about additional laws related to tenancy. Security deposits is a big topic. People wonder, can the landlord ask for 3, 4, 5 months of rent? No. Civil Code Section 1940.5 limits the amount that a landlord can charge for security deposits. It's 2 months rent with some exceptions. And it's important to enforce that. If the landlord is trying to ask for more, you do have to say no. It's 1940.5 says you can only charge 2 months. And it is a way that landlords are trying to prevent certain groups of people from moving into certain neighborhoods by asking for multiple months of rent for security deposit. One of the other important provisions of Civil Code Section 1940.5 is that the security deposit must be returned to the tenant within 21 days after move out. And that's an important provision. The code section specifies what the landlord is entitled to deduct from the security deposit, and also has limits on what can be deducted. And so it's important to know that when you're moving out, that if you've lived there for more than 2 years, the code does not allow the landlord to charge you to paint the place. Paint has a 2-year limit, and judges and decisions all over the state have affirmed that no, the landlord cannot charge you to paint an apartment if you've lived there more than 2 years. So it's important to know what the landlord can take out under 1940.5, and you're entitled to demand that accounting in the 21 days after you move out. The tenant can say, you know, I need the list. And actually the code section, some people are surprised, but when the landlord says I'm going to charge for X, Y, and Z, the landlord has to have an itemized list of X, Y, and Z, and also must have the identification of the contractor who's going to perform that work that the landlord is going to charge you for. So this next section is important because now under the law, there are very many disclosures that are required by law that landlords are required to disclose. For example, if this is a non-smoking community, if sex offenders are going to be reported under the penal code, if this landlord is complying with the California Toxic Mold Protection Act, which requires the landlord to provide a mold booklet or information on mold at the time you rent the apartment, and is also supposed to tell you if the apartment has previously been mold infested and went through mold remediation. A lot of landlords are violating that provision. And I have a whole webinar that I do on our YouTube channel called What to Do About Mold as a Tenant, because mold is a very common topic that we're getting referrals from tenants for. And I spend a lot of time during the week talking to tenants about how to address mold. And the only thing that the Toxic Mold Protection Act of 2001 requires is that the landlord give you the booklet and supposedly notify you. But it is the job of the tenant to assist the landlord in identifying mold and helping to clean it up. And also, there are exemptions of property from various laws. For example, if single-family homes, some single-family homes are exempted from the laws related to tenancy. Some homeowner associations. So you have to also look at what exceptions might exist under these statutes. Some of the other important laws that relate to landlord-tenant relationships include the Costa-Hawkins Rental Housing Act for housing built after 1996, and that governs rent increases under Civil Code Section 1954.52. The Ellis Act is something that's happening a lot in the rental market, where the landlord claims to be going out of the rental business, and so you tenant have to move move because this unit will no longer be rental property. The important provision of that code is that the landlord cannot be lying and saying and really trying to move you out just because they want to get market rate rent for that unit. And so a lot of landlords are saying that they're no longer in the rental business, but then they go and rent. If that happens, the tenant who got moved out has the right to move back in, and you have the right to enforce the Ellis Act provisions, the right of first refusal if the landlord turns around and starts renting again. I also wanted to highlight the city and county of San Francisco has declared that mold is actually a public nuisance that violates the public health law. And there you can see that health and safety code section there that is enforceable in the city and county of San Francisco. Many jurisdictions around the state of California are attempting to encourage the enforcement of such a type of law, but it's very difficult because mold is everywhere in California. There's also the California Health and Safety Code. There you can see this code section 17920.3, which defines substandard housing. And actually it includes a subdivision that says visible black mold infestation. It creates substandard housing, but the way to enforce that has been very difficult, and housing advocates all over the state are attempting to do that. One last law that I mentioned that is not listed here is a federal law, the Violence Against Women Act. That's a very important federal statute that gives tenants who are domestic violence victims or survivors a number of rights. And you can watch HERA's domestic violence series. A number of those webinars are going to be presented later in the Ask a Lawyer series. So if you're interested in how VAWA applies to you as a tenant, you can look at that. Next, we're going to talk about some fun things. Your lease terms actually should answer these questions: who, what, where, when, and how. And you should be able to answer these questions as a tenant. Who is the landlord or owner? The lease agreement you receive should identify that person or persons. Who is the management company? Is there someone other than the landlord that the tenant needs to contact for problems at the property? Who are the tenants? Are all the occupants who are going to live in this apartment identified on the lease? You don't want to have unauthorized people living in the apartment, so that raises a possibility of the landlord having a reason to try to evict you. Are there pets? Are there service animals? Are there emotional support animals? Those are three different categories of legally acceptable animals in apartments, but they all have different legal requirements. HERA does have a webinar on pets, service animals, and emotional support animals, three different legal categories. And also, is there a pet addendum attached to the lease? Does it specify what type of pets you can have, that you can have emotional support animals, and that you can have service animals? You must not be prohibited from having those. Also, does it tell you who the landlord and tenant has the responsibility to do certain things? Who has the duty to provide parking? Who has the duty to do what? And so that's leading into the what category. How long is the rental? What will the term of the lease be? Is it a year versus month to month? Is the address of the unit correct? This is important. Sometimes people think they're renting one unit and they go to move in and they're told that's not the unit. You look on your lease, make sure it's the correct apartment. And what's included? What is the size of that? Is it correct? Is it the 2-bedroom and not the 1-bedroom? A lot of voucher holders with Section 8 vouchers need to ensure that they are being approved for the proper size unit that their voucher covers. What is included with the unit? Are there appliances? Is there air and heat covered? Is there a pool? Is there some recreation room? And do you have access to that? And are there additional rules and regulations attached to the rental agreement? Many large apartment complexes do have a separate list of rules, R&Rs, they call them, rules and regulations, that are also binding on you. And that's why they're referred to in the rental agreement, to make sure you read them and know what the requirements are. So here are some where questions. Where do you go to pay your rent? You need to know that you're paying your rent at the right location so that you can't face a claim that it wasn't received. Communicate with the landlord. Where do you send notices that your washer needs to be fixed, that there's water leaking? Is there an emergency contact number? How do you communicate with the landlord? Is it in writing only? A lot of people want to text and email their landlord when their rental agreement says communication with the landlord shall be by US mail, at this address. And so you have to know where to communicate with your landlord. Where do you submit maintenance requests to make sure that they're responded to? Is it online? Is there a portal that you have to log into? That can be a problem for some people with no technology, who don't have the ability to access a computer to submit a maintenance request. If that's the case, you need to know that up front and be able to talk about that with your landlord. Next, where do you get mail? Where do you take your trash? Where do you park? All of that should be specified for a tenant prior to moving in. Do you pay utilities? There's an S missing there. Do you pay the utilities, or are they included with your rent? You need to know that. And there should be a utility clause in the rental agreement that specifies this, because some large apartment complexes aggregate the utilities and then charge each tenant a portion of that. So you need to be understanding how your utilities are going to be charged to you, or are you signing up with SMUD or DPW or whatever by yourself, and those are the only utilities that you'll be responsible. It can result in a great increase in your rental amount every month, and so you need to know that up front. And also, when can the landlord come into your apartment? This probably belongs in the next column, but the landlord will have an entry clause probably in the lease agreement that says, usually Civil Code section 1954, 24 hours. The code actually says a reasonable amount of time, and a lot of people interpret that to be at least 24 hours notice. It does become a landlord-tenant issue many times. When is the rent due? You need to know that. Do you have a 5-day grace period? Do you have a 3-day grace period? Is there going to be a late fee charged? If your rent is late, you should know that. And if you're going to be late on your rent every month, you need to know that you might need to work it out, because there are some lease clauses these days that say consistent late payment of rent constitutes a breach of the lease. I wouldn't sign that, but I would want the lease to comply with Civil Code 1967. When do you move in? Make sure you know that. When is the lease renewable? Or is it? Or does it revert to a month-to-month tenancy? I try to tell people, renew your lease if you can, because what you're doing is securing an entire year of rent at that price, rather than a month-to-month tenancy that could give the landlord the right to give you a notice of rent increase every 30 days or to evict you every 30 days. So know when the lease can be renewed or not. And when do you have to give a move out notice if you want to move? When do you pay a late fee, as I alluded to earlier? And how do you get things fixed through maintenance? How does it look at move-in? Now, this is an important topic because many landlords are providing a move-in checklist where the tenant can check off boxes for everything. Yes, the dishwasher is clean. Yes, there's a washing machine. Yes, there is an oven and stove. But there is also a place usually on these documents to comment if things are in disrepair. And this is important for a tenant to do because when you go to move out, they're going to hold you accountable for the things that are broken that you claimed on move-in were in good working order. I've talked to many tenants who say the stove never worked, the garbage disposal never worked. Well, you should have noted that on the move-in checklist and protect yourself and ask for it to be fixed. I've seen tenants live 6 and 9 months without heat. You can't do that. You have to ask for that up front. And so do you live, how do you live? Can you smoke in your apartment? Can you smoke anywhere on the premises? Many apartment complexes are becoming totally non-smoking communities because of the scientific evidence that's coming out about secondhand smoke and even third-hand smoke. And so can you have guests over at your house? A number of leases illegally violate a tenant's right to freedom of association under the Constitution and tell you that you can only have a certain number of guests at your apartment on a certain number of days. And, you know, some of those clauses are illegal. So look at what limitations are trying to be placed on your style of living. Are you allowed to have a subtenant? Are you allowed to sublet that second bedroom? Are you allowed to have people grill? Are you allowed to grill on your balcony? Those are all questions about how you can live in this apartment. Who is responsible for pest control? Is the landlord is responsible under the law, but is the lease trying to pass that responsibility on to you by including a clause that says you are responsible for pest control within the unit? Also about mold, the same thing I said earlier, is the landlord giving you the mold booklet, telling you how you can improve mold infestation in your unit and work with you? Is there a bed bug addendum? That is required by law now for a landlord to tell you if there has been a bed bug infestation. So these are all about how you're living as a tenant and what addenda have been attached to your lease. Because I tell you, the current lease that I found legally acceptable that had all of the appropriate addenda attached to it, including a flood hazard addenda in California, the community policies, the animal addendum, the addendum about flood insurance if needed. All of those pages and documents on a really good legally enforceable lease is about 30 to 59 pages long. And I urged all of the tenants out there to please read your lease when you get it. I'm going to go through these two implied lease terms. One is the implied covenant of quiet enjoyment that comes with every lease in California, that it's implied that when the landlord rents that apartment to you, you can quietly enjoy your apartment. And this is one of the reasons there are noise clauses in the lease, so that all of the tenants are mutually responsible for not having a noisy place. And you remember that your co-tenants and neighbors are entitled to quiet enjoyment of their apartments too. There's an implied covenant of habitability, which now actually has become a statutory requirement in California and can be found at Civil Code Section 1942 that specifies that a unit has to be habitable, which means that when the landlord rents the place to you, they're asserting that it is livable, that it's habitable. And so as a tenant, if it's not, you have to document the habitability problems. HERA has a public workshop on our YouTube channel specifically dedicated to habitability, and mold is simply one habitability issue that I did a special workshop on mold. So you can watch HERA's habitability and mold workshops on our YouTube channel. So we're actually, I am surprised that have gotten through this so fast. I actually am right at the place I need to be because we want to try to answer some questions. I see that we do have some questions, but this next screen is a list of some resources, and it's not an exhaustive list of resources. It's a list of places which are easy to access and where tenants can get additional information about being a renter in this great state of California. This first one, the Tenant Power Toolkit, is a great kit that was put together by defense advocates in LA County to help people who might have to help themselves in an unlawful detainer lawsuit. And even though it is geared for LA County, you can look at the forms in there and help yourself as well, no matter what county you live in. The next reference is to the Housing and Urban Development website, which is for the U.S. Department of Housing and Urban Development, and has all the laws related to public housing, Section 8 vouchers, HUD-VASH programs, and all of the federal housing programs that exist. The Disability Rights California is a great self-advocacy website. I mean, this organization is a great organization throughout the state of California, helping people with disabilities. And there are some self-advocacy programs, webinars, fact sheets on their website that you can access. And they also have many, many resources for disability-related discrimination, housing and homelessness resources, immigration, in-home health services, and even how to access the small claims court if you want to sue your landlord in small claims court. This next resource, the Apartment Owners Association of California, I only list because it is actually the landlord's resource. A lot of landlords go on this website. I think it requires a membership fee, but that's where some of these lease agreements come from, the American Apartment Association of California, and they try to teach landlords how to properly put together a lease to present to their tenants. The California Apartment Association here, this is a good for both landlords and tenants, has up-to-date forms, leases, and agreements. So if you want to look in general at what an acceptable lease agreement looks like with the blanks, you can go on here and look at up-to-date forms. There's another landlord association, and this is just to let tenants know that landlords do have a lot of resources at their hands to help them be good landlords. Doesn't necessarily make for good landlords, but there are a lot of resources. And there are also tenants resources available. So one is at this library, the Sacramento County Public Law Library. They have a great civil self-help section in the law library that has all the NOLO Press books for understanding basic laws, but the one they have for tenants is called Every Tenant's Legal Guide, and there's the call number for it. It's a very good book for just the lay person to look at and understand their rights as a tenant. This website, findlaw.com, is where you can find any law, legislation, code, or case. You may even be able to find local ordinances on findlaw.com. The California Civil Rights Department is formerly called the Department of Fair Employment and Housing. Last year, they changed their name, and they're called the California Civil Rights Department, CRD. instead of DFEH, and they enforce the California civil rights laws. So if you feel you've been discriminated against by your landlord, you can look on this website and fill out an online complaint. The EEOC is the federal agency that enforces federal civil rights laws. So if you live in federal housing, in a public housing program, you may have a right to file an EEOC claim. Actually, I shouldn't have put that because EEOC is only for employment. But the HUD website is where you can go if that is the federal agency that can enforce your rights under the fair housing laws. And the COVID, this is just a link to the Governor's Office of Emergency Services if you ever want to see if there are emergency orders similar to what happened in January in the state of California, where we had large flooding and fires. And you can go on this website to find out if there are any emergency orders. Finally, the law library resources. If you need to conduct legal resource, this library, the Sacramento County Public Law Library, is a great resource where you can find free legal research materials to help you understand your options. They're located at 609 9th Street in Sacramento, right near the Superior Court. So easy to find. And online materials, there is a wealth of online materials to access at www.saclaw.org. And you can also get through to the reference department with that email address that's listed. And you see the phone number there for contacting the reference department at the library. The librarians here are very helpful and very knowledgeable. You can also access HERA's resources if you need to talk to a lawyer about housing topics, about landlord-tenant issues. You can contact us at inquiries at www.heraca.org or inquiries@hera.org, or you can call our intake line here, 510-271-8443, extension 300. And leave a message, and an admin person will call you back and set up an appointment with the appropriate attorney for the type of question or problem that you have. So we have a wealth of resources available for tenants to figure out what your rights are and how to address them. And if you come to a point where you need help, please contact us so that we can work through it with you. Now, before we do the Q&A, I just want to note that we have a brief survey. It's really short, asking you to link to the survey in the chat box and respond. And then we're going to go ahead and take some questions. So it looks like we do have some Q&A requests. Let's see. Was I at the mental health conference? I don't think so. I'm not sure which mental health conference, but I do go to a lot of mental health stuff. What if you live in a tax credit establishment? Is it true that the landlord can request your taxes? Well, I believe what is being referred to by this question is what's called the low income tax credit housing. It's actually called, the abbreviation is LIHTC, Low Income Housing Tax Credit. LIHTC buildings are actually not federal housing programs. They are tax credits and those programs are administered by the U.S. Treasury Department. A lot of people get confused and think that HUD is responsible for LIHTC buildings. HUD does assist LIHTC landlords in setting the rents. And so in that way, HUD does get involved with LIHTC buildings, and LIHTC buildings are listed through HUD. You can find out where they are through the National Housing Database. But and and the other question in this is it true that the landlord can request your taxes? Well, if you live in any federal housing program, including, I said a LIHTC building is a treasury building, but any of those federal programs or federally subsidized housing, the landlord does have the right to request income verification. It doesn't necessarily mean requesting a copy of your tax return, but there are some very specific federal regulations on the documents that get used to verify income for public housing residents. And so it would require a knowledge of where your building is, what type of federal program it is under, and therefore what federal regulations. Most of the federal regs are 24 Code of Federal Regulations, Section 5 or Part 8 that govern most of the regulations on how public housing or publicly subsidized housing tenants get screened for their income. And there's some very specific regulations. Next question is, what if you are unemployed? Can your rent be reduced? That's an interesting question, especially during the times we are living in, where many people lost their jobs during COVID and did not find employment or were collecting unemployment. Unfortunately, that is not a legal provision that your rent be reduced simply because you no longer make the amount of money that you did when you originally rented this apartment. Because as I said earlier, the rent agreement is a contract where you agreed to pay that amount of rent for that period of time. And if you are now unemployed and you no longer can afford that rent, you may be able to find some rental assistance program, and HERA may be able to help you do that. We do have a number of resources in various counties around the state to access rental assistance for people. But a lot of that has gone away since the COVID pandemic has lessened. There is not a lot of COVID relief money. Most of the COVID relief money actually dried up some time ago, but there still may be some housing assistance programs available for you if you are unemployed and therefore you fall in a low or extremely low income category. Public housing may be your option, and getting into that is a challenge. Another question, I've been in my place 20 years and my landlord refuses to paint. I've also asked to replace my rug to tiles and they are not following through. Is there any recourse? Well, obviously with every legal question that depends, but there is, after 20 years, obviously you should be able to get your place painted. And if your landlord isn't doing it, as a tenant, I probably would employ the procedure of repair and deduct, where I'm going to tell the landlord, you're not getting next month's rent because I'm painting the whole place. After 20 years, it seriously needs to be painted. And I think you could make a case for a repair and deduct where you're going to have the place painted and charge it to the landlord through your rent. That might also apply to the rug. The problem with the rug, it's a little different than painting. The rug is considered a fixture maybe to the apartment. And so to be able to change from rug to tiles might be a substantial change in the premises, and you might not be able to do that without the approval of the landlord. This sounds like something you should call us about so that we can really work through it, look at what your lease says, and look at the reason why, if any, your landlord is not properly responding, because they do have a duty to maintain the premises in a livable and habitable condition. And if the paint is 20 years old, I can't imagine that it it looks good or that it's habitable. And that same thing, if the rug is 20 years old, I could imagine that might be a health issue. And you could possibly call the public health inspector and have it. In fact, I had a prior landlord some years ago who refusing to do the carpet, and the public health inspector, or it was the code enforcement officer, came through and noted that the carpet was buckling and warped, and so said, landlord, yes, you have to replace that carpet. You have to do something, maybe not tile, but we did end up getting tile because it was better for the durability of the floor. But that's something to try to get the landlord to work with. And if you've been living there 20 years, you probably have an antiquated rental or lease agreement that does not comply with the law. So you might want to talk to your landlord about their duty currently under the law and giving you the proper renovation of your place to upgrade it, to make it livable. So maybe you could call us and talk to us about that. Let's see, there looks like there are some more questions. My security was not returned because I did not clean up the piles of roaches behind cabinets and hidden places. Can they do that? As I stated earlier, Civil Code Section 19, is it 1940.5, says that the landlord has to give you an accounting within 21 days after you move out to tell you what was deducted from the security deposit. It's 1940.5. Civil Code Section 1940.5 says that 21 days after you move out, your landlord is supposed to send you an accounting. It's a letter that says, this is how much your security deposit was. This is what was deducted. And if they're deducting for pest control, they have to give you the estimate from the pest control company that they are hiring to prove that that is the cost of this service. And they have to justify it to you. And you do have the right to ask for the estimate. But the problem with them trying to say that this sounds like they're trying to say you created the pest problem. And this question has a lot to do with what has occurred during the tenancy and whether the pest problem existed. Like I talked about earlier, the move-in checklist. Were there pests in there when you moved in? Is there a pest control addendum attached to the lease? What does the lease say about what the landlord is supposed to do to clean up vermin and pests in your apartment? And if it was there already, it was a problem that they should have cleaned up, and you are not responsible. But there is a question about whether your lease says that your landlord is responsible for pest control. And if so, then no, they can't be taking that out of your security deposit. And you probably should be demanding from your landlord an itemization of where your security deposit went. What was it? Because it doesn't take an entire security deposit to get one treatment of pest control. There is another question. How are things different if someone is living in public housing? The thing that is different for public housing is that there is another layer of regulations that govern public housing that don't apply to private rental housing, private market rental housing. Public housing through the Sacramento Housing Redevelopment Agency, it says, this is housing and urban development property. These are federal housing programs such as housing choice vouchers, Section 8 vouchers, the Section 2. There are a number of federal housing programs, and those programs are normally administered in Sacramento. You've identified the Sacramento Housing and Redevelopment Agency, which is the public housing authority in Sacramento. So that is where tenants of public housing have to go to get issues addressed. And in some public housing, the housing authority actually is the landlord. So you have to know where your housing is. In Oakland, for example, there are 3 public housing projects that are managed by the Oakland Housing Authority. So that's the place, that is the landlord, the Oakland Housing Authority. You know, and all over the state of California, there are various housing authorities in each county and city and some local. So you need to know who the jurisdiction is for your particular public housing. And if that housing authority is your landlord, that's who you communicate with. And normally you would know that because your rental agreement will have a HAP, housing agreement, that is executed by the housing authority, that somehow reduces or subsidizes your rent. And that is noted in your rental agreement as to what your portion of rent is versus what the public agency is going to pay for your rent under your voucher or whatever program it is. So I hope I answered that question adequately. Next is, at a future presentation, can you go over nuisances such as noise and remedies? Some years back, I had a neighbor move in below me. They started using some loud, noisy contraption every evening. I started getting insomnia. I asked them if they could be quiet between 10 and 7. Landlord did nothing. This was in Alameda County. I looked up allowable noise levels, bought a tape recorder and noise level machine. I contacted the nuisance abatement division. I sent in my tape because the noise was over allowable levels. They sent out a letter to cease and desist. Tenant ignored and they were evicted. Tenants need to know what to do in cases like this. Well, again, you said this is Alameda County. You also said that you asked for quiet between 10 and 7. As I stated earlier, many lease agreements in this rental market, in this market today, have a noise clause in it. And many of the noise clauses around the state say that there must be quiet between, many of them say 8 p.m. to 8 a.m. So your request for 10 to 7 isn't unreasonable. And it is, though, the landlord's responsibility to enforce the noise provision of the lease. And it sounds like from your incomplete hypothetical that this problematic tenant beneath you did get evicted with the assistance of the nuisance abatement division. Every county and every city does not have a nuisance abatement division, but there are various public entities, and I would direct you to, like I said earlier, HERA has a webinar on habitability. HERA has a webinar on lease agreement. I'm trying to think of one of ours that might address this, because the mold one does talk about contacting public officials, because you have to do that to prove mold. But it really depends on whether there is a local ordinance that governs noise in your locale. Otherwise, nuisance is a very specific legal thing. I mean, it's a legal tort, basically, and proving nuisance is very difficult. But I don't think we would do a presentation just on nuisances, because nuisance law is not exclusive to landlord tenant. It governs a whole lot of situations. But if you feel that a co-tenant is creating a nuisance, your remedy is to go to the landlord and attempt to enforce the noise clause of your lease. And it sounds like, Michelle Lewis, you did a great job of getting that tenant put out. You sent the tape in and the noise was over allowable levels. Good for you. It really depends on where you live. You said Alameda County, that there is a ordinance or some type of specification of what allowable noise levels are. It looks like we still have more questions and we're at the end of our hour. So if your question didn't get answered, I would urge you to contact our inquiries at heraca.org. You see it up there on the screen. And put your question in there and ask to have one of our tenant team attorneys, that includes me, but one of our tenant team attorneys can have a specific consultation with you. We do free 1-hour consultations on specific tenant issues. And so if you want to have your question answered, please contact us and we'll get you a consultation. Thank you for whoever said thank you. And we will see you at the next Ask a Lawyer series. It's next Tuesday, isn't it? Tuesday, 2 Tuesdays away, the 28th. And it's on a debt and credit issue. So I hope you'll be joining us then. Thank you for joining us today and hope you got some good information. How was it?